OKFM 101.7.
Na mami kwa na mi kodi nkomo we na afiara de munim se eboja ye no na ano ehyepa na lawyer Godwin Edudzie Tamakloe, director legal affairs of the NDC and yene ne era twetwe nkomo yi oyine me moche
bra kwa me anopai me jo so me jawe chawe tiefo nyina
atiefo nyina agye oso na enura mukọ court na enkomo ba ko eye yewura Dr. Kezato Folsom ene owura Richard Japa ekesi no de copy mu ba ye ne say yes sa recordings no court no admit into evidence na recordings no eye mu de he ebisi telephone recordings ebinum say oh yes ba ko bi kwa wa esi wo yewura judge of the Supreme Court Yoni Kolendi fee tape ban na afei say you admit bibi into evidence ya say na ti
you kwame no pay me chow with you for because we acquire a ruling of the court, we can just do a public discussion without going into the merits of the other matters.
Sure.
Now with said I think a few things have happened that puts things into proper perspective. Sebi, Okaya, the national chairman, a board that week as a press conference. Ovie yeno, Nyamixin San David, a babon silver can say, audio no is doctored together. But a talker.
Mekaipa.
And now, after me call ya the Soa. In fact, there once and now after the mistrial ruling, me back that one. And I may be say that way, what can I say? A, B, C, D, echoes, I won't come between war and intelligence, no crap. Or say, none besides say, that is now on my or standing by that testimony if you want or say, or standing by that testimony. None besides say, or evidence via a backy and some now, or na. And I was number one, not true, or pen drive. It is Mr. Judge, a permission, so on coffin, no man who can occupy it. In Tiabai, and I say, usually the evidence to make us sure may seek the permission of the court to tender it through him. And I may don't judge no counsel okay, but per the protocols, before we admit documents, per section 6 of the Evidence Act, or say the question of admissibility or otherwise should be taken at the time the evidence is being offered, and not at that time. So whether you object or not, it should be taken now and then. In the Ecobasa, my kind of say. My Lord the Judge, I can say, Attorney General, who will objection be a na. But before me take your objection, now I say, Unchi Adiana, I was our audio, no so first. But what I say, you see, Ecobasa, or Momo can say, and now, my Lord, I can't say, okay. Sebi, or the mom who cry. In the end, survey of Friday. Before I ever back court on Tuesday. It's now say you court Thursday, no men could be and fanto envelope move na and filing so that the Attorney General will be said before the Tuesday. Nyame ya dom. Ye call ye the next Sabi. My kind of say court no I can say okay. Yembo record no. Emma Ubia from beginning to end. The TABPA, our open court. Family, you and a judge will be say, now one, ye Attorney General who objection be na Attorney General say or objection. Sebi Obia Oba on behalf of Attorney General. Miamenyonko, Deputy Attorney General Alfred Chiayebua. Chiayebua did not in the year politics. I think that's when no original secretary or so. When people are going to have Sunyane into Oyogia.
Na Sassam no kwe. Say now we because more about to discount the story say on yes sir.
Oh no, Chiayebua they are a very fantastic lawyer.
I mean lawyer, but say oh yeah communication officer, BC communication.
No, and he appear him.
And appear in okay. Sorry.
We may can't deputy agent. Very
deputy agent. Okay.
Very fantastic way. Yeah, politics. Maybe I have no go you know. Indeed, maybe I agree. DPP, Director of Public Prosecution, raising issues, more objection. Almost grounded the objection in 3 material areas. One, almost at the time, not be lazy, me cross-examine Japan. Before I made the audio, no, accept the banner. Man laid sufficient foundation. That was their first ground. 2, and then they say audio, no, and yet relevant to the issues for determination. 3, the audio, no, was procured in violation of Article 18.2. What is in Article 18.2? Article 18.2 says, Obi animal crime say obey interfere with the privacy of somebody's communication or on the property. It said the Obi family who will fear can be animal interfere with the privacy of our house. The yes and may violate the Constitution. But that Article 18.2 there were exceptions. If you are all fighting crime, said you who was serious suspicion said Uncle is here a private property, a bopper to overthrow the government. Now that suspicion is very, very strong and potent. Who knew kinds of train said because of the privacy of the Obuye Intino or train.
To say issue been a buy secession is binu and sembino.
Like recent coup plotted.
Exactly.
One we said WhatsApp chat, audio recording, videos and all were admitted in evidence. Okay, the Republic versus Kwabnameni and
Tago. Yeah.
Audio recording also in the house of a police officer. Now were admitted. But what you say?
Me too.
Almost raising these 3 almost raising objection on the basis of these 3 grounds. And yes, so you can't say. First of all, the evidence acts on relevancy, or say sufficiency is not a ground to object on relevancy, because you don't need to prove the whole. Even if a part is enough.
Even on the surface of it, okay.
Once I would me, and I can't say, would see audio nana. Prosecution ankasa the exhibit 8 a class for auto force and extra to BOG. The request for the LC. On the audio recording was a discussion on the LC. And so your own exhibit 8.
A discussion here, a matter that is before the court.
Exactly.
Okay.
And it borders on even the establishment of the LC. Because UTA audio now, the back and forth between Godfrey Adame. Anyway, one of the issues they discussed was whether the 200 ambulances, it was one global contract, or they were supposed to have a contract for 50-50. They were supposed to come in 4 tranches, 50-50. And what was the LC supposed to do? And whether there was advance payment. All these matters were discussed copiously on the audio. And so to say, there is no connection between the discussion on the audio and the matter set down for trial. It's problematic. And yes, someone who say Article 18.2 no. In fact, the senior barrister or no opposing objection no can say. Sabio menena eye kwekubuahi matter no.
Okay.
Aha, ye defend kwekubuahi. Inti you can't say. In that Kukuba matter, you raise objection to the tendering of that audio recording. The same attorney general court ever can say, no, the audio is relevant. Courts are admitted. So at this point, what do you mean, you don't choose the forum where you advance particular legal arguments. There has been a ruling in that matter, and that is why the audio recordings were taken to the Israeli Forensic Institute for authentication and others. So it is too late in the day, sir. Attorney General Babe advances her argument, you know. Into Ebasa, my lady, the judge, I can't sue. Yemra, Enra, Thursday, Yawada, na Oma, the ruling on it. At the end of the day, or say, on the principle of fairness and reciprocity, she will admit the audio. The next stage is to determine the lawyer for a kind of what weight to attach to it. Right, I mean, Obi be aware the law of evidence. I bet you say evidence is not counted. You don't count evidence. You weigh the evidence. It should be able to be court with 50 witnesses. Obi should be court with only one witness. At the end of the day, the 50 witnesses will be giving contradictory statements. We can do on the same fact. We go and we see no see a handman no over, and I mean she Kwame no see handman no over. The same issue. For 50 witnesses have been contradictory statements. If you're Bastana, even though if we were counting evidence, then you would have brought 50 evidence, quote. But because the evidence is weighed, it goes into the credibility of the individual. And once you've established that they are not credible, 50 now will be of no use. Meanwhile, Obi, and sometimes, like we always say colloquially, consistency is truth in the law of evidence. Consistency. If Obi back, the witnesses, they have given a consistent storyline. Also, they win one. The court may prefer, inferentially, the testimony from the other compared to it. If the now the back and forth meaning that my lady the judge admitted audio recording. If you are now yet to also in cross-examining Japan on the basis of the details in the audio recording.
So the audio recording no my press conference mo boy and now where you different from
the same thing. It's Mr. Nyami Senior Frank Davis. Oshia, in fact, I'm not very on fast food now on friend on an abin na on fast food no mon fair on for jam mosquito. No more apologize to him. So Chairman General Yankani no form
I'm apologize I can't say.
Someone can say keep now Chairman a boy and a doctor.
But you admitted into evidence and say you are now going to test it.
Judge media at the doctor state.
Okay. Okay.
No judge will ever admit a tape that is, or said you make a recording that is.
Can we say, sir, can we say, sir, tested evidence?
Sadie ya Godfrey Damiaye. Obi bia obi defending the bia be good in the master first. Meka actual. Obi a obi defending Sadie no. I just will go on one in the master first. Back on me. I have a plan home. And here we are.
Martin, Mamu say.
Obi bia be na agin say. Obey defended that way. Unless you disgrace yourself, you must first disgrace yourself before you can defend it.
Lord, mommy, you may addition, by admitting it a sad tape recording into evidence, you know, does it mean, sir, now it has become a tested evidence?
Has it become what?
A tested evidence. Just say, tested.
Yes.
Okay.
When we say, Bible says, gold, refined gold must go through what? Fire. And yet the fire that refines the gold. And yes, sir. It is the fire that refines the gold. It is the fire that destroys the impurity. That is how the law of evidence is. And yet the objection is breaking it down. And at this point where the evidence has been subjected to rigorous legal argument and they pass the admissibility test, the only thing that is left at this point is weight.
Okay. Now, law, Mamie, Nancy, Mammy, ruling on this tape, 34 page in the back.
Okay. Yeah, on the mistrial.
On the mistrial. Na Sabreno Mukofa tape you want somebody Emma many comments and say no just the legal general legal counsel no near the idea no. And na say so one admitting to evidence. Nimi no yani ayeni mumrei say na obechiri machire.
Yo. Brother I would say the issue set down for the mistrial was a simple question of mistrial and whether the conduct of the attorney general should be referred. They can say, in my respective view, I think it's a key. I think a very fair quote unquote approach. For sure, the matter borders on the conduct, quote unquote, of a lawyer. In that respect, the General Legal Counsel is disciplinary because if I make a finding at this point, it can affect the licensor or the practice as a lawyer. Remember, I said he's first a lawyer. And I don't want to go into that. Go to the General Legal Counsel. And also, I say a statute will do specific provisions in the Criminal Offences Act and the Criminal Procedure Act are 30 on mistrial. If you take it, what colloquially we can say a conduct violent approach. Menka so why bonny, menka so when you're bonny. What are you? But you go to the governor of Judea. You could do one. Welcome to when we So there are two distinct matters. And in fact, that was how they premised their objection to the admissibility. But in the superior wisdom of the judge, they said no A, B, C, D. And no. Welcome.
Marty, but it says, monestage is saying.
So, see, I'm not yelling about the
okay.
In Namiyaduma on Tuesday, Attorney General best started the cross-examination of Richard Jaffa.
I see.
Then, yes, sir.
It's not just any Tuesday in the beba so.
No correct.
Oh, Mati. Anyway, your mamma no was it. Na yes, so yeah, that's a pass at the Biaoji Berena, a ja uche chimusi na.
OKFM 101.7.